enter the box. And by entering the box, we'll have the opportunity to elicit from her more evidence, more issues will come up, her calculations of the various numbers, why she declared and came back, gazetted it and came back to change it with the press release. All those issues are issues that, if we have had the opportunity to cross-examine her, would have helped enrich the case, and I think that would have helped the court to arrive at a better justifiable decision. But the court didn't agree with that. So we will do our best under the circumstances and come out with whatever we have.
Will you pursue any alternative outside the court to get this testimony or this information that is crucial to your case, or crucial to what your perturbation about the 2020 election results?
Well, we have made it clear that any opportunity to us will be explored beyond the court. Any opportunity to arrive at the truth of this, because we still believe firmly that this man can account to the people of this country. We still believe that we have not decided a constitutional duty. We still believe that it is important that the people of this country know exactly what happened, why a person who had 49.225 is ruling this country against the constitution of this country. I think that you still have to decide the duty as a constitutional duty. And we will not spare any opportunity to make sure that she comes to the country.
Without getting into any prejudicial matters, does this ruling, in a way, harm, the petitioner's success with regards to the main petition? Because severally, the petitioner has tried to get the testimony of Jean Mensah, and all those attempts have been shot down.
No, I don't seem to understand what was. Can you please repeat the question?
So my question is, what's your expectation of the outcome on Judgment Day, if I may say? Because your case, I wouldn't say was hinged, but was largely quite dependent on the testimony that Jean Mensah would have given. And now that all the avenues have been shot down, is it fair to conclude, without getting into any prejudice with the court, that that may harm the outcome of the petitioner's case?
No, yes, as of now, honestly, we cannot predict any position. Honestly, we can only leave it to the court to come out with their judgment.
Okay.
We will not be able to preempt or say anything that we expect from the court, but we expect that with the evidence before the court will come out with different conclusions. Honestly, we cannot predict anything now. But you can see that we are clearly not satisfied with the proceedings in court. We are clearly not optimistic of what will happen in court, because we think that we've not been allowed to make our case in full. We still think that we have not received our view. We still think that the process was not fair to us. And so, even though we accept what the Supreme Court has said, that we are still not happy and we don't agree with them. So, as to what will happen on the 4th, we cannot predict, we cannot talk about it. We leave it to the judgment of the court.
Very well. We'll leave it here. Thank you very much, Baba Jamal. He's a member of John Mahama's legal team. Henry Nana Boakye is still with us in the studio, but I want to quickly go to, you want to quickly make a comment?
I just wanted to, yes.
Very well.
Because Baba made reference to Section 72, right? And even today, Section 72 was misquoted. Let me quote. You see, we thought that first it was inadvertent mistake on the part of the petitioners. But when we also heard Mr. Chachu Chikata repeated the Section 72 when he was reading this particular section on his feet, he intentionally also omitted an important word. Now, let me help you with that. Subject to the discretion of the court, in a civil action, a party or a person whose relationship to the party makes the interest of that person substantially the same as the party may be called by an adverse party and examined as if on cross-examination at any time. This is the catch. This is where the issue is. At any time during the presentation by the party calling the witness. When you read the Evidence Act itself, it is during the presentation of evidence. And Mr. Chatuchi Kata intentionally omitted an important word, which is evidence. Okay. Do you know why? It is because you may have to do that when you have not closed your case. So once you close your case, because during the presentation of evidence, meaning you are still conducting your case. You have not closed your case. So he tried to even swerve the court. But yes, indeed, our lawyers brought him to order and mentioned that, you know what, during the presentation of what? Presentation by parties. No, it's presentation of evidence. So I just brought this in to throw more light on the fact that you can call that person when you are still conducting your case, not when you have closed your case and you have moved on.
Very well. Let's speak to Justice Abdulai. He's a private legal practitioner. Good evening to you and thank you for joining us, Justice. I want to first start with your views on today's ruling. Is it fair to say that it was expected?
It was expected for several reasons. I will probably start by saying that this is the third in the series of that application for a review. And indeed, it's about the 7th or 8th of applications from the petitioners, most of which ostensibly were targeted at either reopening or subpoenaing a witness, and all of those applications, the Supreme Court had given a particular decision. Now, what we heard today from all sides, from the petitioner, from the respondent angle, and indeed from the Supreme Court, were all rehash of all the other decisions involving the same subject matter. Now, going into an application of this nature, we should understand that indeed the petitioners were going into this application as the losing party. The odds were against them, against him. Sorry, let me put it that way. The odds were against the petitioners because naturally of the previous rulings and the previous applications. Now, and so you could clearly see from that angle that they had a Herculean task to overcome. Coupled with this is also the issue of having to make a completely new argument that would convince the court to change all the previous decisions. If it was the first time, you probably would have a better chance, maybe a 50-50 chance, but this was a third time. And you are coming into a third time in the same, almost with the same argument, and taking the Supreme Court's perspective of all these arguments that have been made and edged on it, you would come to the conclusion that they are looking out for the petitioner grounding his applications on the basis for a review application. According to the Supreme Court, from all the three rulings that have been given, none of it were grounded on the basis of the law allowing for a review. The law has procedure for a review to be mounted on it. From the angle of the Supreme Court, almost every application for review from the petitioner side had come as an appeal, but mounted and camouflaged as a review. And so today, the Supreme Court, if you notice that the Supreme Court took its time to detail out the grounds for a review and grounds for an appeal. Because as far as they are concerned, once again, the petitioners were unable to convince them based on the grounds for a review application, for which reason they ought to disturb their previous decisions. Now, that is the first one. The second one, which is largely on the back of this thing, is that I was, as a third party sitting on the fence, asking myself, these 4 or 5 applications, or 6, that have been mounted, all with the view of reversing, with the view of getting the Electoral Commission subpoena and also for the petitioner to reopen this case have all been rejected. No fresh argument has been urged on the Supreme Court. So as a third party sitting on the fence, I'm asking myself, what will be a basis for the Supreme Court this time to say that today you have made a completely new argument, strong enough for us to disturb our previous decisions? For me, that is the kind of argument that I was looking out for. Unfortunately, as said earlier, it was just a rehash of the previous argument. We didn't hear any single, in fact, not a scintilla of a new argument was made. And so, really, on this angle as well, I'm asking myself, really, why would the Supreme Court disturb its previous decisions? Because if you have already made these arguments and they've rejected it, coming in this time, naturally you should be saying something different. You should be coming with different language. You should be coming with different laws. You should be coming with different reasons upon which you strongly believe that if they relied upon those, they would change their previous decisions. But we didn't see that coming. And sadly, we had the ruling the way it had gone. I cannot pretend to be better than all the lawyers in the matters, whether on the respondent side or on the petitioner side. But as an observer, I was expecting this new, fresh argument, a fresh argument that would naturally incite me to sort of give my backing to the argument.
One provision in the Evidence Act that became quite profound today was Section 26. And it was relied on by the petitioners on two fronts. First, if anybody acted or if anybody gave you that cause to believe that maybe they've said something, they've acted in a particular way, and that tilted or that also directed your mood, then the person is stopped.
What you lawyers call the estoppel principle.
Yes. So, and then again, under the Section 26 in the Evidence Act, that is what we call the conclusive presumption. So, okay, so in this case, if you apply it to what we have now, what the petitioners are saying is that because Madame Jenny Mensah, in her affidavit, stated that when there is a need for her to mount the witness box, she can also give some of, she can respond to some of these interrogatories, right? Don't forget that all of these things came as a result of the application for interrogatories to serve interrogatories on the EC. Okay, but then the argument is this. You put in an application for interrogatories. You saw these affidavits, you read them. You did not come to the court to say that because we have seen the EC or because we have read from the affidavits of the EC stating that, oh, when she mounts the witness box, she's going to throw more light on some of the questions that we are asking. Then in this case, we are no longer pursuing the application, right? We withdraw the application. No, you pursued the application to its logical conclusion.
You would have expected them to bring the said evidence to the courtroom?
Yes, because, no, what I'm saying is that you are saying that you relied on the statements of Madame Jane Mensah, right? So you believed, so you were expecting that she was going to be in the witness box.
Yeah.
Now, the argument is that you did not, because you should demonstrate that indeed you relied on these statements as put out in the affidavit.
What was your expectation then of them demonstrating?
No,
they would have demonstrated it
yes,
if she came into the box.
If you relied on these statements and you had 100% belief in them, the most essential thing to do was to come before the court and withdraw the application. Say that, oh no, we have read from the affidavits, the lady says that she's going to mount the witness box. Here is the case you pursued, you fully argued your case out, you pursued the application, and in fact, you even went for a review of that ruling.
So you would have expected them to state specifically exactly in the affidavit.
In the affidavit. No,
what
you didn't
it
come. I mean, the most important conduct was for them to come and withdraw the application so that it will be a scene that indeed they have fully relied on the fact that the woman will be mounting the witness box. In this case, you did not. So that is why this particular provision is not applicable. Secondly, if you consider the opening statement of Section 26, it reads, except as otherwise provided by law, including rules of equity. So that is the more reason why the submission from the Council for Petitioner that it appears that Supreme Court made the CI 30 Order 38 Rule 3 E5 subservient to the Evidence Act is wrong and is misconceived, because even the provision itself gave room to consider any other law. Don't forget, CIs are part of our laws. Article 11 of the 1992 Constitution clearly states the hierarchy of laws, and CIs are part of our laws and rules of equity. So in this case, you have a witness statement, and we have rules regarding how you deal with witness statement. So they sought to rely on Section 28 of the Evidence Act on two fronts. But in all of that, their grounds were wobbling.
With those wobbling grounds, how does Judgment Day March 4 look like for you? For the second respondent?
No, we have always maintained that the case of the petitioner is frivolous, is vexatious. They have not demonstrated that they meet the legal threshold, and that they have no reasonable cause of action. We've mentioned it. And we even mentioned it in our answer, right, that we intend to raise preliminary legal objection. So we maintain, and then we have proved that, in fact, the three witnesses that came, they even further deepen our minds, our thoughts, our belief that indeed this petition is frivolous, is vexatious, it lacked merit, has no reasonable cause of action, it doesn't meet the legal threshold. We've mentioned, we've maintained, and it's still. And every day we are fortified in this belief.
So your expectation is that come March 4, the court will do it?
Oh, we are hopeful. Obviously, when you go before the court, you are hopeful that you don't want to predict, you don't want to prejudice the matters, right? But then once we believe that our case is strong, robust, we've made our case, and we are of the view that we will prevail.
And the petitioner hasn't made their case?
They haven't. We've stated it several times. And
very well.
Yeah, several times we've mentioned it. So we are. And today, I think one matter that also came up strongly was the contempt.
Yes.
Charges slapped on Mr.
Dr. Dominic Ayeni.
Yes, Dr. Dominic Ayeni, a very senior colleague, very unfortunate. And I'm happy how he has exhibited absolute humility. I mean, this is a learning period for all of us. Our utterances, myself inclusive, our utterances, and because, you know. So
was it fair then that he was asked to retract and apologize publicly when a lot of you lawyers had been in the media or on the airwaves saying things that, you know, were a bit difficult?
No, you see, his words were problematic, because you see, you can give commentary, you can twist and turn it how, but you need to be careful when you say that the court deliberately has narrowed the 5 issues outlined to 1, and the agenda behind this is predetermined, directed at the petitioners, and the predetermined mind to make sure that the petitioners.
He said the ruling smacked of a predetermined agenda.
That is very unfortunate, very unfortunate. And when you say that, in your case, you think that Madame J. Mensah conducted herself unlawfully, and he did so many wrong things.
But many of you, yourself, Kojo Opon-Kroma, had severally said that the petitioner has no case. The petitioner has no case, but that's something the courts will decide, not you.
You don't get my point. That is for us against the petitioners, because we have an adversarial system. So myself against the petitioners, I can say that you don't have any case. Then
even though it's something that will be decided by the courts.
No, that is what I'm saying. Even in our answer, right? Because you are claiming that nobody won the elections and that a rerun should be conducted. I'm also saying that you don't have any case. Your case is frivolous, vexatious. It's the same thing because it's an adversarial system. But when you extend such attacks to the very people who are supposed to look at all of these evidence before the court and make a determination, is dangerous.
Okay.
Right? So, I mean, some of these attacks can be leveled against. I mean, they are allowed, although you should not degenerate into something.
It's a thin
else.
line, isn't it?
Of course, but
Very well.
but some of these statements that you make, but today, as I said,
he retracted and apologized, and I guess that settles it.
I mean, that is my respect for him has really shot up.
Well, that's made him a hero, at least in your eyes.
Yeah, I mean, yes, because you see, sometimes when you come before the court, you do something and then you apologize. It makes you a better person.
Very well, we'll leave it there.
Yeah.
Thank you very much. That's Henry Nana Boakye, a member of Akufo-Addo's legal team. That's the second respondent. On the phone, we had Baba Jamal, a member of John Mahama's legal team, and private legal practitioner Justice Abdulai. We're grateful to you for your time. I'm Francisca Kakra-Force, and the news will come in a bit.